This is something for those of you who practice civil law. Criminal law, as you already know, is very different from civil law, and the criminal appellate process is somewhat different. And we'll get more into the substantive component of that, but to help you, we're going to bring forth our very distinguished panel, which will include, as you can see on your agenda, Robert Hurst, who is a CPD, Circuit Public Defender of the highest quality from the Ogeechee Judicial Circuit. You have a bio that was handed to you with your packet, so I'd just like to touch on some of those things that are mentioned. Robert has been a CPD, Circuit Public Defender, since 2004, and he has extensive experience in working with appeals. He's going to be facilitating the panel that has two other fine appellate scholars, Chris McFadden, who, as the bio says, wrote the book on appellate practice, and you will be well inclined to take a look at that as you go through. Always follow the rules. That's one thing about appellate practice, as you know, follow the rules. And we also have Tom Stubbs, who's done extensive work, successful work at the Court of Appeals and at the Supreme Court. And now I'll ask them all to come up, and we'll start with the nuts and bolts of appeals. We'll have them each present, and then you'll have time afterwards to ask questions. So with that, Robert, Tom, and Chris.
They have names on each side, so I know who I am too.
And I'd like to think I know who I am.
It's a search that's ongoing, and it was the search, or in your teenage years.
Good morning. My charge today is to give, at the outset of this, is to give you an overview of the appellate practice. Acknowledge that I'm talking to a lot of people who have got considerable appellate experience, I guess primarily in the civil area. And much or most of what I will say will be things you know very well. But I hope perhaps there'll be a few. I will be focusing on it from the criminal perspective, and I hope even for you there'll be some useful insights. So let's start from the very top. Why do we have appellate courts? What's the purpose of them? Now, Georgia didn't always have appellate courts. A unique feature of its history is for about 60 years at the beginning of the Republic, the General Assembly had decided that it did not want a Court of Appeals or a Supreme Court. The creation of such a court was controversial for a long time. Governors urging the creation of an appellate court argue that, you know, without one, what we've got is it's simply tyranny. We've got Superior Court judges who are entirely supreme, appealable to no one, and that's not law, that's tyranny. Eventually that idea, of course, prevailed, and we now have our appellate courts. But it's important to understand that really is their function. I have spent the past couple of years on what seems like a continuous odyssey explaining what the appellate courts are, and particularly people who are terribly engaged in politics, but engaged primarily in defending the state of the nation from the depredations of the other party, and less interested in the judicial branch. In trying to get their attention, I have settled on the idea of invoking an ogre. What about this terrible judge who says, "Don't tell me the law, I am the law"? That's why we have appellate courts. And it really is why we have appellate courts. And the reason that I say that is to draw your attention to the fact that courts, that as you move up the system, the individual case begins to matter less. And the focus of the court is more on the system generally, the law generally, than the particular injustice in the case. Judge Dorothy Beasley, who was served many years on our Court of Appeals as one of the most distinguished judges there, used to say that the Court of Appeals is a processor of process, which is a truly soporific description. But her point was that the justice under law is really the charge of the trial courts. The charge of the appellate courts is really just to make sure that the rules are followed. And in the appellate courts, as you know, those of you who have done civil appeals, the focus is not so much on whether the result was right, but did the judge make a mistake in processing the process? Now, of course, that can include a mistake in determining that there's enough evidence to go to the jury. But that's what brings us to standards of review. standards of review are absolutely fundamental to any appeal because it's fundamental to the function of the appellate court. And they boil down to asking, what is it that we're challenging? What we want to be challenging is a judge's failure to comply with existing law, because if we can characterize the issue that way, what we have is de novo review. We've got a law issue where the appellate court owes the trial court no deference. If we want to talk about the facts, we need to understand we're dealing with what is, in essence, the summary judgment standard. All the disputes have to be deemed resolved against you in order to prevail on that basis. That's the any evidence rule. And if we're into discretionary decisions, we're in even more difficult straits, because the standard of the abuse of discretion standard of review tends to be deferential in theory and almost prohibitive in fact, not entirely so. It is a very difficult to apply. And the basic analogy is similar to an ultimate boss and an immediate supervisor. An ultimate boss will not, if he's good at what he does, get involved in micromanaging every management decision that a mid-level immediate supervisor would handle. And the analysis is similar on the appellate court. The trial judge was there, he saw the people, he weighed the demeanors, he knew the intangibles. So that understanding of the role of the court as it relates to standards of review really should underlie everything that we do as appellate lawyers. Now, I want to shift now to talking about the process, and I'm just going to give a bird's eye view of what the process is. And as we do it, I'm going to break down more or less chronologically. And as I do, we'll be focusing on the role of the advocate. And I want to distinguish three roles that appellate advocates, appellate lawyers have in the process. Three functions that they have that are sort of distinct. One is that their responsibility is to preserve appellate jurisdiction. This is relatively simple, but obviously terribly critical. That means figuring out what the deadline is, and that's 30 days after final judgment. In criminal context, that's 30 days after sentencing. Make sure that it's directly appealed, that almost always is in the appellate courts. But there are, for example, some authority that would say the discretionary procedure, where you have to ask the appellate court's permission before you have a full-blown appeal, applies in certain insanity defense cases. You also have to determine that you do have a final judgment, which obviously, if the defendant has been sentenced, that's not a problem. But exceptions to finality exist in our system, and they apply in criminal cases in the case of double jeopardy. And they apply in cases of violation of the right to a speedy trial. There's an exception where those are immediately appealable under what's called the collateral order doctrine. Now, in terms of preserving error, there are basically two things you can do. You can file the appeal. Obviously, timely done, that invokes appellate jurisdiction. The other thing you can do is file a timely post-judgment motion. And under Georgia law, which is different from the federal law, there are three post-judgment motions that preserve your appeal rights. Those with motion for new trial, the motion for judgment notwithstanding the verdict, and the motion in arrest of judgment. Motion for new trial is probably the king of the three, so I'll address the other two briefly. J&OB, motion for judgment notwithstanding the verdict, is essentially summary judgment part 2, part 3. And it applies essentially the same standard. Motions for judgment notwithstanding the verdict are not available in criminal cases, only civil cases. In criminal cases, the available remedy is a motion in arrest of judgment, which serves a somewhat similar function, but actually resembles the old demurrer practice more than it resembles Civil Practice Act summary judgment practice. And the idea is that you have to be able to say, what it says in the indictment, I did that, but that's not enough to convict me. So it's an important remedy that rarely applies. The one that applies almost always is the motion for new trial. Now, why do you file a motion for new trial? You just got convicted, the client and the trial judge lawyer are probably going to tell you that there's sense of demeanor of the trial judge, as to a motion for new trial is fat chance. Nevertheless, you almost always want to file a motion for new trial. For one thing, it's not a bite at the apple. I view it as an opportunity to present to the trial judge a preview of my arguments on appeal, and to give that judge an opportunity to be persuaded by the arguments rather than passing the buck upstairs. In addition, one should be mindful that the trial judge has authority at the new trial stage, but the appellate courts do not. That goes back to Judge Beasley's observation about justice being in the hands of the trial court and the appellate court being a somewhat more arid and limited role. The trial judge is the 13th juror. He or she has the authority to withhold consent from the verdict, and if they withhold consent, they have an unlimited right on that basis to grant at least one new trial. The case law says if they keep doing it, they're entitled to less deference, but I've actually never, I've seen one case where the judge is doing that. It's not very likely. The other reasons are that you can add to the record at the new trial stage. One thing you can do at that stage is you can add newly discovered evidence. This is, again, sort of a theoretical option, although one certainly should be aware of it. There is case law in Georgia that says if you've got newly discovered evidence, you can go back to the trial court and file a motion saying, my gosh, look, I'm accused of murdering this person. Well, here's Joe. Here he is. Here's the guy I'm supposed to kill. And the case law says that's sufficient. And the case law says pretty much nothing else is. There's a case called Dick against State that lists 6 or 7 criteria. They basically boil down to you have to have a really, really good reason for not having presented it before, and it has to be really, really compelling. And in practice, those provisions pretty much are an unlimited license to always deny the motion. But the remedy exists, and an appropriate case law to be invoked. The function of a new trial motion that is, I'm sorry, they're just so unique that the really important function of the evidence receiving power of the new trial motion is ineffective assistance, and there it is key. And I should just mention parenthetically that one of the other constraints on the appellate courts is they have no power to hear evidence. If it develops that evidence has to be presented to them, they've got to somehow get rid of the case, get it sent down to somebody else, so that evidence can be heard and brought up. You have, with respect to ineffective assistance, it is now pretty much mandated upon at the direct appeal stage. The rule is that you have to assert it at the first opportunity.